Good evening. I'm Troy McKenzie, Dean of the Law School, and it is my privilege to welcome you to this year's Robert A. Katzman Lecture at NYU School of Law. This lecture honors the late Judge Bob Katzman, who was a brilliant jurist, a scholar of public institutions, and a tireless advocate for education about civics and advocate for access to justice. Many of you know how much he meant to our community here at the law school, both as a teacher and as a human being, and tonight's speaker carries forward many of the interests and commitments of Judge Katzman. Judge Katzman was no stranger to the NYU community. He was a teacher here, as I mentioned. He was also someone who, over the years, participated every summer in NYU's Institute of Judicial Administration seminar for new appellate judges. In that capacity, he taught a generation of new judges going on to the appellate courts, both federal and state, on those topics that are not necessarily ones so scintillating you would read them in the papers. He taught about statutory interpretation and brought to that discussion a true, informed, and fascinating eye. One of the joys of participating in those seminars over the years when I was a faculty director of the Institute was seeing judges who otherwise would be nodding off in that kind of discussion suddenly realize how fascinating and difficult questions of statutory interpretation could become. Bob had the benefit, of course, of an extraordinary background in approaching questions that bridge the divide between the courts, the legislative branch, and the executive. He was an academic, both as a lawyer and as someone with a PhD in politics. And he brought that perspective to his work. Over the years, he used his role as a judge to decide hard cases, but also to advocate for greater education about the role of the courts, about our structure of government, and the interaction among the different branches and levels of government in the United States. In 2011, he came to NYU to deliver the Madison Lecture, which formed the basis of his book, Judging Statutes, a response to trends in statutory interpretation at the Supreme Court of the United States and a persuasive encapsulation of his approach to the task. In 2018, NYU's annual survey of American law dedicated its 75th volume to Judge Katzman, with Justices Sotomayor and Ginsburg speaking to honor him at that time. In January 2021, when he took senior status at the Second Circuit, he came to NYU full-time as a professor of practice and would have been, I know, a long-standing contributor to our faculty, but for his untimely death that summer. In Lina Khan, we have a public servant, academic, and thinker who follows in Bob's steps. She is one of the most important legal minds working today on questions of economic power, regulation, and the design of legal institutions. She is a scholar and a public servant and a leader of one of the most consequential shifts in legal thinking in the last generation. She earned her undergraduate degree from Williams, a law degree from Yale, where she wrote a student note that I'm going to talk to her about, a student note that was so groundbreaking and drew so much attention that it reframed the conversation about antitrust law in the digital age. Her influence did not stop at that stage. She served as a staffer for the House Judiciary Committee, and then was nominated and confirmed as chair of the Federal Trade Commission, appointed to that role at the ripe old age of 32. That's not what I was doing at age 32. The New York Times has described Lena and her scholarship as having reframed decades of monopoly law, and Politico called her a leader of a new school of antitrust thought. So we are delighted to have her here this evening, and I will conduct a conversation with her. And just as a word of warning in advance, if I seem completely ignorant in this conversation, it's not an act. I know very little about antitrust. I know just enough to be dangerous, and I'm sure that Lena will set me straight. So please join me in welcoming Lena Khan. Welcome to NYU. It's always like this when a speaker comes to NYU, just so you know. We have an extraordinary turnout, including many, many students who are fascinated by your work and by you, so I know we will have a great conversation. I wanted to begin at the beginning. How did you get interested in questions of competition and antitrust law?
Well, first of all, let me just say it's so wonderful to be here and such a great honor to be here in remembrance of Judge Katzmann. I didn't have the fortune of getting to know him personally, but was a close student of his writings and scholarship on the Federal Trade Commission and the bureaucracy, and a great admirer of his clear-eyed awareness that his role as a judge and the legal enterprise as a whole is not some academic project, but is instead something that affects people in their day-to-day lives, and that's something that I tried to keep top of mind at the FTC, and so it's just so meaningful to get to be here. My path to antitrust and questions of concentrated markets was somewhat circuitous. I had wanted to be a business journalist and spent my time in high school and college reporting. I ended up graduating right in the midst of the financial crisis, and so instead ended up working for a think tank where my job was to document how various markets had evolved. And so I spent years doing deep dives into industries like the chicken farming industry, airlines, book publishing, rental cars, and it really gave me this ground level understanding of how various markets work and how over the last 40 years we had seen waves of mergers and acquisitions and a general trend of consolidation, resulting in more and more markets being controlled by fewer and fewer players. Part of my job was also to document what the effects of that consolidation had been. And so I would spend my time calling up farmers and saying, hey, there was this big seed merger a few years ago. They promised that prices would be lower and there would be more innovation. Has that actually happened? And through that work, got a 360 view of the different ways that extreme consolidation can hurt people, both through higher prices, but also through lower wages, through market access being closed off to startups and entrepreneurs, as well as a ability for unchecked monopolies to really abuse their power and coerce people in their day-to-day lives. And so that got me really interested in the antitrust laws. And I was really fascinated by how, on the one hand, we had these remarkable set of laws on the books that were passed against the backdrop of the Gilded Age and deep concern about the role of unchecked economic power. And yet, on the other hand, we had all of these markets that had become so consolidated. And I was really interested in that gap. And that took me to understanding what had happened in the 70s and 80s with this legal revolution ushered in under President Reagan. And I decided that I wanted to go study antitrust at law school, and that's what ended up happening.
So when you got to law school, I mean, was it clear to you that antitrust was having a moment, or was it something that you thought was going to be interesting to study, but not necessarily an area where there was much to say? And the reason I ask is, I went to law school in the late 1990s, and I can remember the Microsoft case was happening at the time, there was a sense that antitrust was having a moment, and then the moment passed. And if you had asked me 10, 12 years later, I probably would have thought, there's really not much more to say. There's a model and a paradigm, and we're not going to shift out of it. So, there might be interesting cases here and there, but a basic rethinking of the premises of American antitrust law is just not going to happen. Did you think that way when you got to law school, or was that sort of not even on your radar?
I mean, it was definitely viewed as somewhat of a quirky interest, especially if you weren't interested in kind of going to, go do M&A at a big firm. It was certainly, being interested in antitrust was certainly not viewed as any type of path to kind of prestige or power in government. I do think that generally, though, there was a greater awareness and interest in the sets of laws that structure and govern economic power and corporate power. There were a set of people that had come of age during the financial crisis and became very interested in how, we could use our laws and policies and ways to create markets that were more compatible with core democratic values. And so I did find that generally there was a cohort of people that were interested in scrutinizing and potentially rethinking areas of business law, be it IP law, be it trade law, be it bankruptcy law, be it other parts of kind of corporate governance. And so antitrust was part of that, but antitrust in and of itself was somewhat marginal to the broader conversation.
So you're in law school and you publish a student note called Amazon's Antitrust Paradox. This is not your ordinary student note because it got a tremendous amount of attention. Can you tell me a little bit about how you found this idea, how you developed the note, and what the experience was like working on this piece of student scholarship?
So this note grew out of some of the work I had done before law school, where as a researcher and reporter, one of the last projects I had started on before starting law school was starting to look at e-commerce, and specifically Amazon. And I spent a lot of time talking to two sets of market participants in particular. One was the set of businesses that were selling through Amazon and tried to understand what their experience was. And the other was investors and financial analysts that were kind of viewing Amazon through a more long-term prism. And through those conversations, it became clear that for these two sets of market actors, they viewed Amazon as having achieved structural market power and a structural role as a gatekeeper that had huge implications for markets. That was out of step with how economic policymakers in DC were generally thinking about Amazon, as well as antitrust enforcers. One of the most significant cases that implicated Amazon at that time was actually a case against the book publishers, who, feeling squeezed by Amazon, ended up coordinating in ways that the Justice Department viewed as illegal and ended up bringing a suit. And so it was especially remarkable that the closest that Amazon got to being affected by antitrust laws was through a lawsuit that was actually going after its business partners who were teaming up to take on Amazon. And so I got to law school and kind of was looking through these notes and decided to use Amazon as a vehicle for telling a broader story about the evolution of antitrust, in particular because two of the business practices that I identified as being central to Amazon's strategy were precisely those areas of the law that had become most affected by the Chicago School Revolution. And so I used it as an opportunity to show what I thought were major blind spots in antitrust jurisprudence and blind spots that became especially acute in the context of digital markets, given various dynamics there. It was a long process. I mean, I spent like the bulk of 2 years in law school working on this.
Can you say that again for all the students in the audience?
Okay. It was kind of more a kind of passion project, and that I decided, let's just kind of see if it gets anywhere with submitting it to law journals. It did not get accepted on the first go. It was, I think, outright rejected the first time, and I think maybe the second time it got like an R&R. So it really wasn't even clear to me that it would get anywhere other than just being an interesting paper I had worked on. Shortly after it got published, though, I actually started hearing from general counsels at major firms that were kind of running into various challenges with Amazon and hadn't kind of figured out what the right was to be framing their arguments, and that was pretty
Pause for a
surprising.
second. What was the network that got that from the pages of a law journal to general counsels?
I have no idea. It's a great question.
You didn't send reprints to everybody? Okay.
I think it just kind of emerged on the kind of, law review website, and then, maybe it was like blogged about somewhere, and somehow it got the attention of some folks.
And what piqued their interest?
I mean, I think there were a lot of firms, including major Fortune 500 firms, that were starting to feel Amazon's power structurally. In terms of the types of demands that it could make, in terms of what they viewed as coercion. There were some firms that both were extraordinarily dependent on Amazon, but as Amazon itself expanded into new markets, also found themselves competing with Amazon. And that dual relationship as both extraordinarily dependent on a firm that is now becoming your biggest competitor, I think was something that was kind of a nascent awareness, and my paper just put more of a spotlight on it in a way that I think drew their interest.
So am I right that the sort of standard view at the time would be Amazon enhances consumer welfare measured by short-term price effects, basically? And therefore, it's a good thing because people can find goods that match their needs at low prices. So what could be bad about that? And if the booksellers don't like it or others in the market don't like it, they don't like it because they can't extract higher prices from consumers.
I think that was a dominant view. I think another core piece of this was the view that switching costs are very low on the internet. And if you as a consumer don't like Amazon, well, you can just type in a different retailer and go elsewhere. Similarly, there was a view that for suppliers in particular, Amazon had dramatically expanded their market reach, and that was an enormous benefit. And sure, if that came with certain costs, then that was just part of the bargain. I do think as a general matter, in the early 2000s, there was a view among policymakers, including antitrust enforcers, that digital markets were extraordinarily fast-moving. They were very dynamic. We had, billion-dollar companies that were emerging from a handful of people working out of a garage. And so there was a view that the entry barriers were very low. And so that monopoly power was unlikely to ever form, but if it were, it would be quickly disciplined away by the new competitors that would emerge. And that thinking, mapped very much onto the thinking of folks like Judge Bork and Easterbrook and others that had basically offered a view of antitrust enforcement that said, under-enforcement is going to be safer than over-enforcement because markets will self-correct any monopoly power that goes unaddressed by an enforcer, but an erroneous judicial opinion arising from misguided antitrust action is much more difficult to dislodge. And so that kind of what's known as the error cost analysis had really pervaded scholars and enforcers for generations. And I think what we've now learned over the last decade is that in digital markets, that calculus can actually be entirely inverted, where because of how network effects and the self-reinforcing advantages of data work, monopoly power that goes unaddressed by enforcers early can be much more difficult to dislodge. And so I think that's just been learning that has happened among academics and enforcers over the last few years.
So I know in the world of the Fourth Amendment, there's a sense that the Supreme Court has recognized sort of explicitly that the digital world has changed things. The way you should treat a cell phone in the search context is different. Do you think the same kind of shift has happened or should happen in the antitrust context, that with the digital markets are just different? Or is it really, no, they're not different, but operation of factors that we might think are going to go in a particular way will just be unusual or won't have the same kind of effect that we might assume they would have in a digital market?
I think we're seeing this play out in real time. There is currently a big trial going on, FTC versus Meta. There was just a verdict issued in one of the DOJ's cases against Google. There is another trial happening around remedies that should be issued against Google in another case. And so several of the antitrust lawsuits that were initiated by the federal government, several of which were actually started during the first Trump administration and then were continued during the Biden administration, we're now seeing opinions issued from those cases. And I think it is going to create a great roadmap for scholars, but also for members of Congress to be able to identify, okay, what parts of these laws are still alive and well and able to address monopolistic conduct in digital markets, and where might we see certain gaps. Google has now been found to have illegally monopolized 3 different sets of markets and 3 different sets of cases. And so, these are extraordinarily difficult cases to bring and win for the government. And so I think it's no small accomplishment.
So I want to turn to your time at FTC, but before getting there, you're a professor at Columbia, and you're starting to teach. You're getting into a great career, and then you get nominated for the FTC. What was your first thought when you knew that your name was going to be put forward? Did you say, call me after tenure, call me a few years down the line? Or did you think, this is a great opportunity and I'm going to jump at it absolutely right now?
Yeah, I mean, it was pretty surreal, and I kind of suspended belief until I was actually confirmed, because you never know how these things are going to go. But no, I mean, I thought it was an incredibly exciting time to be getting to work on antitrust law and policy. During the first Trump administration, there had actually been kind of key areas of rethinking. I had gotten the chance to work for a congressional committee where we had done a big antitrust investigation in a way that used to be pretty mainstream through the last century, and then Congress became more of a kind of backseat player in antitrust, and now we were seeing, again, a resurgence of congressional interest. And so I thought it would be just an incredibly valuable time if I had the opportunity.
So Judge Katzmann was, of course, an expert on how institutions work and the relationship between Congress and the courts, and also thinking about the interrelationship among the 3 branches. You arrive at the FTC, and there is this growing sense that perhaps antitrust law is primed for a major reexamination. Did you think of that as your mandate when you got to the FTC?
To some extent, yes. It had been no secret what my views had been on kind of antitrust in an enterprise, and what I thought both specific kind of gaps had been in how enforcers had pursued that mandate, and then specifically at the FTC, what I had identified as dormant authorities that I thought should be fully activated. And so, went through the rigorous Senate confirmation process, kind of talked to dozens of senators about that. And so kind of when I got confirmed, it did seem like a mandate to be following through on some of those views within, the confines of a multi-member commission.
So let's talk about your work at FTC. One of the things that you did was to reinvigorate rulemaking about unfair methods of competition under the Act. One thing the commission did was to issue a rule on non-compete agreements in contracts. That was ultimately struck down, but it was remarkable in a way for the sense that the commission was thinking broadly about its mandate and the areas in which competition law had something to say. So from your perspective, what does the commission gain by stepping into an area like that, even when there might be a risk that the courts will end up invalidating the actions of the commission? Is it worth doing something like that, even when you're not assured at the outset that a rule or decision by the commission will survive?
So rulemaking generally was something that the FTC had been very active in through the 70s, and then faced some backlash and generally had not pursued a vigorous rulemaking agenda. There's, of course, a very extensive set of scholarship that goes through the various trade-offs between pursuing enforcement through adjudication versus rulemaking, so I won't rehash that. But for the purposes of the FTC, there were a few institutional advantages of pursuing rulemaking. One was it could lead to more efficient enforcement. And so if there is a practice that you believe is an unfair method of competition or is unfair or deceptive, if you pursue it just through adjudication, each time you're going to have to go through the full doctrinal analysis, you may have to do economic analysis, go do a survey, and it can be quite expensive. If you've instead identified that certain types of practices are categorically unlawful, be it non-competes, be it subscription traps, be it certain types of fraud, once you codify that as illegal through a rule, enforcement is just much more streamlined. You don't have to do the full doctrinal analysis under unfairness or under deception. And so there were just clear institutional advantages given how small the agency is. The other big institutional advantage for the agency, especially with regards to the consumer protection rules, was that rule violations unlock a whole set of remedies that are not available if you're just bringing cases under Section 5. And so, ordinarily, if you're just bringing a Section 5 case, all you can achieve is a cease and desist order. And from the perspective of achieving deterrence, that is, it can be entirely worthless because you have situations where you have fraudsters or lawbreakers that are getting to enjoy the fruits of their lawbreaking and are just having to cease that conduct going forward. And so we thought that especially on the consumer protection side, where certain types of unlawful behavior had become quite prevalent, it was quite important for us to be able to pursue those rules, even though rules take time. For the consumer protection rules at the FTC, those are promulgated not pursuant to the Administrative Procedure Act, but instead pursuant to through what's known as the Magnuson-Moss rulemaking procedures, which are even more onerous. And one of the things we first did when I arrived there was actually look through the Magnuson-Moss statute and make sure that the agency's own procedures were not going above and beyond in ways that were creating excessive red tape. So we ended up streamlining that, and what had initially years ago taken 5 to 10 years when it comes to finalizing a consumer protection rule, we actually were able to do in under 2 years with a whole swath of rules, including a couple that are going to go into effect next month. A rule banning junk fees in the entertainment live event ticketing context and short-term lodging context, as well as a rule that would ban subscription traps, requiring that firms make it as easy to cancel a subscription as it is to sign up for one. The non-competes rule was interesting because not only were we activating the Competition Rulemaking Authority, which had been dormant for some decades, but we were also using our Unfair Methods of Competition Authority that is unique to the FTC Act and that is designed expressly to go above and beyond what the other antitrust laws prescribe. Before pursuing the rule, we actually brought a few enforcement actions, including in a context where security guards making close to minimum wage were bound by a non-compete, and this had really devastating consequences for people. And this was true more generally of non-competes. They started off in the boardroom, but over the last few decades had really proliferated. So they affect fast food workers, janitors, swaths of healthcare workers, and it's something that both undermines people's core liberties, but also results in people being able to earn less and people's, family decisions being really limited. And once we proposed this rule, we actually got 26,000 comments from people all across the country, oftentimes sharing devastating stories about how non-competes had affected them. We heard from a bartender in Florida who was being harassed at her job, decided to go take a job with a restaurant across the street, and got hit with a $10,000 lawsuit. And so she had to choose, do I continue to get harassed at my job or risk this extremely expensive lawsuit? And it was really just quite striking after we put out the proposed rule just to see how many people across how many different professions and walks of life had been really fundamentally affected by this. And so that, certainly renewed our resolve. This was also an area where there has actually been a real surge in economic evidence about the effects of non-competes. So over the last few decades, at the state level, we have seen states take action to limit certain types of non-competes, and that has created more of a natural experiment that has allowed economists to actually limit and isolate the effects of non-competes, finding as a result that non-competes result in lower wages. Interestingly, not just for the workers that are directly affected by a non-compete, but even for workers that aren't. The idea being that if some workers are less easily able to change jobs, that creates less churn and dynamism in labor markets as a whole and affects even those workers that are not directly governed by a non-compete. There was also evidence showing that non-competes have actually resulted in higher costs in areas like healthcare. They have been really harmful when it comes to keeping out startups and entrepreneurs. Interestingly, California has rendered non-competes non-enforceable
For a long
more
time.
than a century. And there are some scholars who actually attribute California's success as an innovation powerhouse to the fact that knowledge and information can be more easily diffused. So
If you're looking for some light reading, all the students, Ron Gilson's article, NYU Law Review, 1999. I know, I had to edit it. It compares Silicon Valley and Route 128, the corridor around Boston, and makes the argument that the reason why Silicon Valley became a much more successful innovation economy is because California, for totally accidental reasons more than 100 years ago, effectively banned enforcement of non-competes.
yeah, it was
It's a good read.
It's a great read. I think we even cited it in our rule text. But so it was something that we thought generally had a big effect on people's lives. Up to 1 out of every 5 Americans has been affected by a non-compete, and it was an area where we thought that private enforcement and private action would not be able to fully cure the illegality of these non-competes or really result in meaningful remedies. Interestingly, even in states that have severely restricted or outright banned non-competes, oftentimes employment contracts still include non-competes. And workers are oftentimes at a significant informational disadvantage. Sometimes you only realize that there's a non-compete in your contract after you've already quit your current job and arrive at your first day, and then by that point you have very little bargaining power. We've also, of course, seen the proliferation of arbitration clauses and class action waivers that make adjudication by workers more challenging. And so this full set of factors, both the kind of strong empirical evidence, the view that we had clear legal authority, and the fact that we thought we could have kind of an outsized set of benefits for a huge swath of Americans, made it worth it.
So can I ask you a question about institutional change? You arrive at the FTC, and at least in recent history, the commission thought that its Section 5 power was really coterminous with other antitrust laws, so it couldn't really go beyond what was otherwise prohibited by some other antitrust statute. That shifted during your time at the commission. What was your thinking behind sort of taking a more expansive view of the role of the FTC under Section 5?
So Section 5 is core to why the FTC exists. The FTC was created in 1914 against the backdrop of a Supreme Court decision in the Standard Oil case. A lot of people think of that decision as being when Standard Oil was broken up, but for Congress at the time, the decision really marked what they viewed as an unacceptable power grab by the courts, because the courts introduced in the Standard Oil decision this distinction between reasonable and unreasonable restraints of trade, and Congress worried that both this decision as well as several others that had been issued really marked a drift away from what Congress had viewed as the kind of primary goals of the antitrust laws. And so that decision comes down in 1911. In 1914, the FTC Act gets passed, as well as the Clayton Act. And both of those were seen as really important institutional gap fillers, filling in some of the gaps that the Sherman Act had left, resulting in monopolization through mergers. But importantly, Congress viewed the FTC in particular as being an important institutional complement to the common law approach that was otherwise governing the Sherman Act. And there was an extensive debate around whether Congress should just ban unfair methods of competition or whether lawmakers should actually stipulate specific practices that they viewed were unlawful. Ultimately, they decided that firms can be very innovative in how they violate the antitrust laws, and so it would be better to create a general prohibition and then expect the kind of experts at the FTC, through using their other tools, including market studies, to be able to basically make sure that the law was keeping pace with business realities. And so, through the 60s and 70s, FTC was routinely bringing cases under what's known as its kind of standalone Section 5 authority, oftentimes in tandem with its consumer protection authority. What happened in the 80s was that there was a trifecta of losses in the federal courts, including in the Second Circuit, and the agency felt very stung by these losses, and those losses were actually very fact-specific. In most of the decisions, actually, the court reaffirmed the fact that the Section 5 authority went beyond the four corners of the Sherman Act and the Clayton Act, but that trifecta of losses ended up just being very psychologically heavy on the agency, and the agency ended up retreating from that affirmative, assertive use of Section 5. That trend culminated in a 2015 bipartisan policy statement issued by the FTC, where they declared that they would only pursue Section 5 cases effectively when there was a violation of another antitrust law. When I joined the FTC, it seemed important to kind of dust off and fully assert the unique institutional authority that the FTC had been given for a panoply of reasons. I mean, I think there are actual business practices that you cannot reach under the antitrust laws that we should be making sure we're going after. I think more generally, for over a decade now, at various points, there have been efforts in Congress to consolidate the antitrust authority within the Justice Department. And so to basically strip the FTC of its antitrust powers and say, we're just going to do this through the Antitrust Division. People can disagree and debate about whether that's a good idea, but if you believe that the FTC having separate antitrust authority really matters, you should actually be exercising the unique institutional authority that Congress has given. And so I thought the risk would also significantly go up if, in fact, we just did our antitrust work like the Antitrust Division did.
Because why bother have an FTC if you're just doing the same thing the Antitrust Division does?
Exactly. Right. Why kind of blunt your own institutional uniqueness that Congress has explicitly said, we're creating you not to duplicate the Antitrust Division, but to do different stuff and to have different tools to do it. If we just say, well, actually, we're just going to act like the Antitrust Division, I think it could be really institutionally damaging. So we started bringing cases under Section 5, including in the big lawsuit we filed against Amazon, as well as a lawsuit we filed against the 3 pharmacy benefit managers. Those cases are still proceeding. In the Amazon case, we defeated Amazon's motion to dismiss, including on the Section 5 issue, and so we'll see how this proceeds.
Great. So I wanted, before sort of closing thoughts about your career so far, I wanted to ask about being at an independent agency. That's how you know you're at a law school, because you say independent agency, and everyone has a wistful sigh. Oh, remember those. One criticism of independent agencies is that, well, they're not really independent. They just do Congress's bidding, and so they're kind of in the executive branch, but they're more beholden to Congress than to the president. And I wondered if you had any reflections on that from your time at FTC. And then obviously, in this moment, there's a concerted push by the current administration to severely limit or perhaps abolish altogether the idea that there can be an independent agency where the president doesn't have direct control. Do you have any thoughts or comments on that? And the answer might be no, but yeah.
So there are a whole set of lawsuits that are teeing up this very question. As you all may know, two of the commissioners at the FTC themselves were fired in direct contravention of Humphrey's executor. One of the arguments that's being made is that
And direct contravention because Mr. Humphrey was a commissioner of the FTC.
that's right. FDR fired him, and he sued, saying, you know, my firing is illegal. He actually ended up passing away before the culmination of the lawsuit.
Hence the executor part.
The
Yes,
executor part.
yes.
But it's you know, the seminal case on agency independence is cited not just for the independence of FTC commissioners, but the independence of all sorts of other bodies, including the Federal Reserve. And so there are now several cases that have been teed up, both involving the FTC commissioners as well as NLRB board members. And so we'll see where all that goes. I mean, practically from my own experience, you know, we were very attentive to what Congress believed we should be working on. You know, we're routinely called up to testify. We're routinely called to weigh in on specific issues of the day. And so there definitely was a real oversight function from Congress. The idea that we were just operating in a vacuum without any democratic accountability was just not reflective of reality. I do think there are a whole set of important institutional benefits that come from independence. I mean, I think right now we are seeing one potential extreme of a lack of independence, the idea that you could have, you know, somebody from the White House calling the shots on major litigation, just depending on which executives have access to the Oval Office. But even short of that, I think, especially given the composition of the FTC as a multi-member commission, there are just enormous institutional benefits to be able to do your day-to-day work at a bit of a reserve from the day-to-day political realities, be it in, you know, at the White House or even in Congress. And there are various features of the FTC that are designed to create that independence, not just the kind of multi-member nature of the commission, but also the way that terms are staggered, 7-year staggered terms, the idea being that you would have you know, turnover, but not at the expense of that institutional expertise. So I'll be watching very closely. I mean, I do think that all said, there is an important conversation to be had about how do we make sure that agencies can be democratically accountable and democratically responsive. I think there is also a conversation happening right now about the various challenges that government can face in acting more swiftly, in acting in ways that make clear to people how the government is benefiting their lives materially in a day-to-day sense. We identified and reckoned with some of those challenges and obstacles internally, but I do think that some of what we're now seeing in terms of attacks on federal agencies and independent agencies is partly born of a vulnerability that is created when there can be a sense of, you know, maybe government isn't actually fully acting in our best interest. So I do think that, you know, my views on agency independence aside, I do think the question of how do we make sure agencies are fully serving the American people is a really important one.
So we have a room full of students here, and one of the things we always try to emphasize is the importance of public service. Do you have advice to lawyers coming out of law school thinking about ways of making a difference who might be interested in working in government or public service, especially in this moment?
I mean, this is a difficult moment for federal agencies in particular, but I feel so fortunate to have had a chance to pursue public service at a variety of institutions, and just can't speak highly enough about it. I mean, oftentimes these institutions are under-resourced, and so the type of ability you have to have significant impact, even in a relatively early stage of your career, is just off the charts. And so I really can't recommend it enough. I actually ended up working for a congressional committee somewhat out of happenstance. I was actually set to clerk on the Ninth Circuit, and my judge ended up unfortunately passing away. And so I was kind of left trying to figure out what to do. And I remember at the time there were people who were kind of like, oh, why would you go work for Congress? But it ended up being just an enormously valuable experience in terms of understanding just the institutional levers that Congress has, especially if we're able to work at a committee. I would say for federal agencies, I mean, these agencies are comprised of extraordinarily devoted, committed public servants, and the amount you can learn just by working side by side with them. At the FTC, I was just routinely blown away about the nuts and bolts knowledge of the economy that this very small agency had, be it about the mechanics of how the cement industry worked or the mechanics of how the grocery industry worked. And so there's just an enormous amount of expertise at these agencies that getting even the opportunity to spend a summer at some of these places can be extraordinarily enriching. So I really can't recommend it highly enough.
Great. Do you have any final thoughts looking back on your time in government at the FTC? Is there anything that you really wanted to do that you couldn't do that you might want to share? A small question, very easily answered, I'm sure.
It's funny, last summer, we started drawing up two sets of lists. One being if we have, another 4 years, what will we want to do? And another being if we only have 6 more months, what are we really going to prioritize? And I will give our team enormous credit. I mean, on the kind of only 6 months left, we really checked off almost every box in terms of the various statutory authorities that we wanted to make sure we were reviving and setting in motion. I'm seeing somebody mouth Robinson-Patman Act, which we squeezed in 2 Robinson-Patman Act cases in December and January.
By the way, only at NYU will Robinson-Patman Act get a big laugh. That's really, it's a sign of quality. Yeah.
Absolutely. I think especially as we see some of the rules being challenged in court, the non-compete rule is actually still on appeal. We got lucky and were sued in 3 different places on the non-compete rule, and so got 3 different opinions. The Eastern District of Pennsylvania said, this rule is lawful, both under Section 5 and Section 6G. And then the Northern District of Texas and Middle District of Florida came out slightly differently. So those are on appeal. Of course, I wish that we had the chance to kind of fully see that litigation through, because I do think that there are very strong arguments on the FTC side, especially textual arguments. So that's something that we're continuing to monitor. But on the whole, I think, feel pretty good about just the huge volume of what we were able to achieve. Before wrapping, I do really want to I see Eleanor Fox in the audience, and just want to acknowledge her extraordinary contributions to antitrust, which have just been such an inspiration for me. A lot of the kind of revival that you mentioned in antitrust over the last few years can really be traced back to Professor Fox's scholarship in the early 80s, where she was kind of sounding the alarm on the risks of the major shift that was happening. So just a real honor to get to have her in the audience too.
Well, that is a wonderful, wonderful note on which to end this conversation. Lina Khan, thank you so much for coming and sharing your wisdom and your experiences. And please join me in thanking Lina Khan.